needs no introduction to any of us, including those of our brothers from Rwanda. But again, she's a champion of technology and access to justice. Her record speaks for itself, and speaking for myself. We joined the judiciary together in 2003, and she went ahead in terms of technology than myself. I'm almost catching up. So Nordin Aji, don't panic. I'm on course. My iPad is not with me because of challenges I explained to the Chief Justice. I left it in Mombasa when I came here, so it came this morning when I was already here. But next time you'll see me in my full technological power. So don't panic, and all is well. Chief Justice Koome, please come and address us, and we thank you very much for your leadership. Please welcome the Chief Justice.
Thank you very much, my brother, Mr. Justice Isaac Renaura. My brother, the Chief Justice of the Republic of Rwanda and the President of the Supreme Court of Rwanda, Dr. Faustin Ntesiryayo. My brother, Justice Renaura, the EU Ambassador Henrietta Geiger, my brother, sometimes I call him my son, Mr. Nordin Haji, the Director of Public Prosecutions, Mr. Neil Walsh, and all the ends of the NCAJ agencies who are present and who are watching us online. The Honorable Joe Moshero, the CS ICT, and the honorable judges who are present. I know some judges who have taken leadership of the technical teams. Justice Grace Genye, who leads the Criminal Justice Reform Committee of the NCAJ, and also Justice Cecilia Githua, who leads the Committee on Probation and Aftercare, and doing a lot of work in decongesting our prisons. All of you present here, ladies and gentlemen, good morning. Good morning. Allow me to thank the organizers of this hybrid conference, working under the auspices of the National Council on the Administration of Justice, for convening this forum for the actors in the criminal justice sector, for us to talk to each other and share our experiences and challenges arising in administering justice in the context of automated justice processes, while ensuring all the time that we protect the substantive rights. Allow me to thank in a very, very special way our bilateral friends from Rwanda, the Honorable Chief Justice and the team from Rwanda for agreeing to share their experiences as champions of justice, and for embracing technology and agreeing to share with us the best practices. I also extend my appreciation to the European Union for supporting this conference through the Program for Legal Empowerment and Aid Delivery in Kenya, PRINT. We in the justice sector appreciate and are absolutely grateful for the partnership with our development partners that enhances our efforts to work together and to surmount all our synergy in ensuring that our criminal justice functions. Speaking of our experiences at the Kenyan judiciary, which my brother, Mr. Justice Renaura, has spoken to, and allow me to thank him because actually, Mr. Justice Renaura, who chaired KMJE, Kenya Magistrates and Judges Association, is regarded as the founder of the NCAJ. Let us give him a clap. It is the NCAJ that innovatively felt, it is KMJA, when he was the president, that felt we needed to work together. Because each one of us used to operate in our own silo. The judiciary, we are there, and complaining endlessly that cases are not moving because the investigating officer has not brought the files, has not brought the witnesses, the prosecutor has come and applied for an adjournment, the investigations are not done properly. And KMJA said, why are we mourning constantly? Why don't we bring together all these actors and discuss our problems? And that is how the Court Users Committee started. And he was careful to spot me in Nakuru and tell me to start the pilot project of the Court User Committees. So that is how far we come with my brother Justice Renaura, with the NCAJ and the Court Users Committee. And nobody knew that today I'll be standing here, the Chief Justice, spearheading and chairing the NCAJ, and Justice Renaura chairing our whole ICT project. Thank you very much, Judge. We appreciate you, and thank you for the support and the work you're doing. The main thrust of this agenda for today is to enhance the judiciary's institutional performance through the ICT and enhance efficiency and effectiveness in the service delivery. An overarching imperative for success of automation of courts is that all actors in the criminal justice, which we call the chain, should all put towards the same end. We all want justice for the person we call Wanjiku. Where courts embrace automation, while the prosecution, probation, prisons, and defense lawyers do not embrace similar initiatives, the automation project is likely not to yield any fruits in such a system. And this is why the speakers before me have spoken about end-to-end automation, so that from the police station, we get that occurrence book. Those of us who have been trial magistrates or trial judges or even prosecutors know the story of the occurrence book. That is where the complaint is launched, and everybody wants to see how the complaint was launched. So if it is automated from that stage, the witness statements are also online. Then we come to the trial and everything is online. Even when the matter is moving from the trial court to the Court of Appeal, everything is seamless. And this makes it essential that all the actors then have to share this vision for integration of automation in the criminal justice system, because we all work towards the same purpose. The measures and strategies we have adopted as the judiciary to automate the criminal justice system have been explained by Justice Renaura, which includes now virtual courts and electronic court filing of our documents. The e-filing system is a homegrown solution that has been developed by the Judiciary Technical Team. The system provides for the court users to submit court documents electronically through an online portal. It was piloted before the COVID-19 pandemic, before the Commercial Division of the High Court in May 2018. And like Justice Renaura has told us, we were really struggling to embrace automation and to embrace technology in the judiciary until COVID-19, with all the tears and all the agony that we went through, all the inconveniences and practices. It had a silver lining, because overnight, judiciary, we had to innovate and embrace technology. And we are not letting go technology, because now if CS Joe Moshero was here today, he would have shared with us what we are doing with the Ministry of ICT to also leverage on this government e-citizen and e-government to make sure that also there is e-justice in all those forums, the Unduma centers, there is a desk for e-justice, and also the constituency apps that they have for ICT can be used by citizens to access the courts. And that is really a game changer as far as we are concerned. Using the e-filing platform, which went live in 2020 and was launched by my predecessor, the Honorable Mr. Justice Malaga, we have now filed a total of 8,314 accounts that we created on the portal, comprising of 4,826 individual accounts, 3,085 law firms, 333 organizations, and 70 state organizations. We have a total of 67,000 matters which were filed, 16,000 certificates of urgencies were filed since we went online, 1,800 orders have been generated, and we have collected over 1 million court fees and fines and deposits as of June 2021. I think we really need to appreciate this feat. We also have a case tracking system for all the courts, which have been internally developed and was piloted also at Milimani Commercial and Tax Division of the High Court. The system brought positive transformation at the court registries with facilities that enable us also to gauge our performances. We in the judiciary are accountable to the people we serve. We do not serve ourselves, and every day we have a duty to ensure that we collect what we have done and put it in the CTS. So it helps us also in gauging our performance. The system has been deployed to all the court stations and has been implemented in phase 1 that was funded by the government, while the World Bank program, which we call JPIP, funded phase 2 and 3. The implementation also involved linking the case tracking system to the judiciary IFMIS, hence creating an efficient and effective process where electronic receipting and generation of digital orders were operationalized. By 30th June 2021, we had a total of 1,300 cases that were captured in the case tracking system. So when you come with a case number, we don't have to go and look for the file. We just go into the system and log in and find the status of that case. The other key milestone is automation of payment for court services. The Judiciary Financial Management System has been supporting the court stations so that we don't have to disburse money per station. It is done automatically. The system is used for the management of the payment of court fees, fines, management of court deposits, and expenditures, which we call AIE management. And this system is now up and running in all our courts. Allow me to talk about the virtual courts, which is really a game changer, even as far as advocates are concerned. The other day I spoke to one advocate who told me she is in the UK visiting her relatives, and she is doing her virtual hearings from wherever she is in the UK. She's just logging in, she carried her files, and she's prosecuting her cases from London. Isn't that a milestone? In the wake of the COVID-19 pandemic, the judiciary leveraged on technology to find ways to keep courts operational, even as the physical courts remained closed intermittently. In the last reporting period, online meeting platforms such as Microsoft Teams, Cisco WebEx, and Zoom and GoToMeet are being in use to facilitate virtual courts. The judiciary has also adopted the use of the video conferencing equipment in support of remote trials. The equipment was installed in 31 sites across the country. We are now looking into the future, and I should point out that the digitization agenda will continue to be a central focus in the judicial process and administration of justice in Kenya and within the NCAJ family, where we have to harness and leverage on technology in the delivery of justice. And it's also a key feature in our vision, which we launched, the Judiciary Vision on Social Transformation through Access to Justice. The vision envisages that technology will be applied to improve case management and all aspects of service delivery. We hope this will enhance access to justice. I was presently pleased the other day when the Chief Justice of England and Wales called me to share with him the experiences of Kenya in ensuring that the poor, the vulnerable, who do not have gadgets and who do not have airtime could access justice. And I was able to share how we are assisting those clients through the help desk that we were supported to mount by UNODC through the print project support. Anybody who cannot access e-services through cyber cafes or lawyers' offices, they come to the court and they are assisted through the help desk. They can be assisted also to use the virtual facility through the office of the registrar or the executive officer. Moving forward, we are hoping to work with the Ministry of ICT to use those Huduma centers, like I said, and also to set up our own desk for help. So that desk has everything they can be able to file, and they can be able also to access virtual hearings. As courts improve this uptake of the usage of technology, we are aware of this digital divide in the context of unequal access to technology, and also the gender aspect of it, and the ability to use technologies by sections of our court users. And this is why we are emphasizing on the help desk and also the Huduma centers that should be able to assist all these vulnerable groups. Because the common manifestation of the digital divide is the lack of access to the internet, but it's also deemed to include the inequalities in access to computer or other ICT-related devices. Some of the major factors, ladies and gentlemen, that exacerbate digital exclusion in the context of access to justice include lack of requisite physical infrastructure. We know of our poverty levels and illiteracy, and lack of computer literacy even among ourselves. But when COVID-19 hit us, even the Court of Appeal where I sat that particular time, and we had people who had never even sent an SMS with a phone. Now they are smart. They use smartphone, they send messages, they use them to access virtual hearings even when they are in their cars. And this is what innovation and technology has done to the judiciary. Judiciary today, those people who never touched those devices which were given almost 10 years ago, now they love their devices. They never put them down. Some of the innovations and strategies that the Kenya judiciary has developed to mitigate this exclusion, I've mentioned the Huduma Center, the government centralized service centers,